Can a state prohibit same-sex marriage or fail to recognize same-sex marriage entered into in another state? The petitioners in this case were same-sex couples, and the respondents were government entities of several states. Respondents argued that it would demean a timeless institution if marriage were extended to same-sex couples. Petitioners argued that far from seeking to devalue marriage, they sought it for themselves because of their respect and need for the privileges and responsibilities. They noted that marriage has evolved over time as we no longer have arranged marriages or marriages based on property exchanges. The petitioners argued that by denying their marriages or failing to recognize their marriages, they were denied equal protection and due process under the law. Respondents argued that the states had the right to define marriage as between one man and one woman, that there is no right to same-sex marriage, and that allowing same-sex marriage harms the institution of marriage. How would you decide this case? Can a state define marriage and exclude certain people from that definition? Or should persons of the same sex be allowed to marry? We'll be back in a moment with the answer. Can a state define marriage and prohibit same-sex marriage or not recognize a same-sex marriage entered into in another state? No, said the United States Supreme Court. In its landmark decision in 2015, the United States Supreme Court found that marriage is a fundamental right guaranteed to all citizens, and that right cannot be infringed upon. The 14th Amendment's Due Process Clause has repeatedly been found to extend to personal choices, to individual dignity and autonomy, including intimate choices defining personal identity and beliefs. The right to marriage is also derived from the 14th Amendment's Equal Protection Clause. The marriage laws at issue were unequal, the court said, because same-sex couples were denied benefits afforded opposite-sex couples and were barred from exercising a fundamental right. The court noted many of the respondents' arguments mirrored those that once fought against interracial marriage. The 14th Amendment requires states to recognize same-sex marriages validly performed out of state. Since same-sex couples may now exercise the fundamental right to marry in all states, there is no lawful basis for a state to refuse to recognize a lawful same-sex marriage performed in another state on the ground of its same-sex character. Remember, it's a matter of law.